All right. And Doug, you want to read your exiting executive session script?
Alrighty. The Advisory Council on Hearing Aids will now exit executive session and reconvene open session at 2:54 on February 15th. So no final decisions were made and no votes were taken in executive session. The public phone line has been muted and representatives of the media may once again report all board discussions and actions.
The phone line has been unmuted. All right, so we are on item number 4 on the agenda, which is policy. So if you guys could all go to slide 7. Slide 7 is the rule petition that the office received. Hopefully you've had a chance to read this. It was obviously written to me. We have to give a response. Let's get down into it. So looking at page 8 of your materials, so this is very specific of what they're recommending. So they're recommending that we amend rule number 331 6700020, number 2, to remove the or parent or guardian of the client. You can see that it's highlighted in yellow, and the strike through, that's the recommendation that they're requesting. They go on to give some facts. They go on to give information regarding the federal government. Like I said, if you have any questions on this, please stop me because I'm just going to whiz through it. I'm assuming you've all read it. So that is the rule petition. And then the next material section is on page 12, and this is where Anne has said, here's the rule, here's the petition that we received, and this is where she is asking the public to comment on the rule. Because when an individual does a rule petition, it starts a timeline and we have to respond by a certain date. So, but part of that timeline also includes getting any public comment on that rule. And then starting on page 13, so Anne works as if like a hearings officer. So she puts everything together so that you could review everything. We obviously only received 2 comments, so they're both in here, but that's what's in here. So the first comment from Chelsea is there on slide 13. Then there's another comment there that starts on slide 14. From Richard Giles. And then slide 16. So we're on slide 16. So when we receive a rule petition, these are the things that we need to take into consideration on whether or not we want to either go in, grant the petition, deny the petition, and if we do grant the petition, then go into rulemaking, that kind of thing. So these are the things that we need to consider. So the first one is the continued need of the rule. So we know that the rule in the statute contradict what is in the federal government's rules or laws. And so we know that regardless of what our statute says, it cannot be in rule, and we, meaning the office, will work on getting the statute changed. So as you know, in order to change a statute, it has to be done by the legislation. So it has to be submitted as a legislative concept to the legislation and put forward into a bill. And then it has to go through the whole process where the legislation has to approve it and it has to work through, and that's time consuming. However, even though it's in the law, if we were to get a case where somebody so if we take it out of rule and somebody says, well, the law says this, but your rule says this, we would take it by case basis, and part of our evidence on it not being a violation of the law would be bring in what the federal government has said. So just so that you know that even though the rule might say one thing, the law says something that contradicts the rule or doesn't include everything. If we were to get a complaint, all that information would be brought forward in that in our investigation to dispute. Does that make sense? Okay. So the continued need for the rule, obviously there's not much of a need because it contradicts what the federal government has said. Number B, I always want to say number 2. B is the nature of the complaints or comments received concerning the rule. Well, you got this rule petition, so there's a comment, and you got 2 comments on that. The complexity of the rule, it's not very complex. It's pretty clear, cut and dry that you cannot waive the medical for a minor. D to me is where I think that it's most relevant because our rule contradicts what the federal regulations are. And so that would be our major reasoning on why we would want to move forward in on this rule petition. Does anybody have anything on that they want to add? I don't want to do all the talking.
Not all of them.
You're doing a great job.
Okay. All right. And then E, the degree to which technology, economic conditions, or other factors have changed in the subject area. I can't think of anything that has changed. I think that it's pretty clear that it's not a technical change or an economic condition change. It's the federal law and the state law don't coincide. And then F would also be the statutory citation and legal basis of the rule, which is kind of what we talked about a little bit, that our rule does not align with the federal regulations, so our rule needs to align. And so I think that's D and F are the main reasons that we need to address this rule petition. Anybody have anything?
Nope.
Nope. All right. So we need to have a discussion on whether you guys think we should grant this petition or deny it. So that's the first concept that we need to talk about. Does anybody want to deny this rule petition?
Is this a vote or no vote?
No, I'm just asking your opinion. We'll do it in steps. Does anybody feel that we should grant this petition?
This is Verheiden. I feel like we should grant this petition.
Okay. So if we grant it, what would you like to see happen? Would you like us to open rules? Do you want us, let's look at your materials, slide 8. It's going to be the easiest for you to follow along. Because it gives the actual verbiage, and this is what they would like to see happen. So they would like it to delete the quote, or the parent or guardian of the client, and have it just say, if the client, who is 18 years of age or older, refuses to seek medical, blah, blah, blah. And then it says the licensee must obtain written refusal from the client on a waiver. So it just deletes the part of, or the parents or guardian of the client. Are you comfortable with just following exactly verbatim their recommendation?
Yes.
Tiffany is. Jean,
Yes.
what do you think?
Verheiden says yes.
Yeah.
Doug says-
Doug,
Yes,
sorry,
ma'am.
I didn't mean to interrupt. Sorry, Doug, go ahead.
I agree, yes.
Okay. And Lorraine?
Yes, I agree.
All right. Okay. Does anybody have any comments or concerns or want to talk about anything else that's in here? Okay. So I think that because I agree with you guys that we should, it would just make it nice and clean and clear to just delete the or parent or guardian of the client. And just keep the rule as is, but just delete that piece and then it will match up. Like I said, I'll continue working on getting the statutes updated. So Heather, I think what they need to do is to make a motion to grant the petition and amend the rule as suggested. And they need to recommend that to the HLO, right? She's giving a non-verbal yes.
Yes.
So if somebody other than Doug, and we can go through that verbiage again if you want, but somebody other than Doug can make that motion.
This is Tiffany. I make a motion to accept the verbiage to change.
In the petition.
In the petition to change the rule.
Verheiden seconds.
So Doug, you have to call roll.
I will. I will now call roll. Doug, I'm here.
No,
Tiffany?
no, Doug,
Oh.
it's whether yes or no on whether you want to grant the petition and enter it into the rulemaking. So
I
yes
do
or
want to
no.
grant the petition and enter the rulemaking, yes.
Perfect. Okay.
Now I'll call roll.
Yes.
Doug's here. Tiffany?
Yes, aye.
Lorraine?
Aye.
Jean?
Verheiden says aye.
Perfect. Okay. So let's talk some more about how this is going to work. So we're going to, the office is going to open rules and file with, so we have to, there's a whole process to this. So we're going to file with Secretary of State, and this is what we have to do, the timeline. But there's a couple things that we need. So Anne's going to need a little bit of information, so she's going to go over a little bit from you, and to be able to add to the filing for the rule. And all we're going to do, like I said, is all we're going to do is delete those few little words. So we don't have to have a rack. We don't have to have a whole bunch of people discuss this. There will be a time for public comment, and we'll address those comments later, but we've got to get the rule petition started. But Anne, do you want to jump on here and talk a little bit about some information that you need to, and Heather can help answer some questions if we have some, but there's a statement that we need to put in the rule filing that talks about the equity, but Anne, go ahead, you start.
Okay, thanks. Good afternoon, Chair and members of the board. For the record, my name is Ann Thompson. I'm the policy analyst for this board and some other boards within HLO. Whenever we do a rulemaking, and some of you are familiar with this and some of you aren't, we have to do things like fiscal impact. What is the potential impact of this rule on small businesses, members of the public? This one is particularly simple, but we have a new requirement created by 2021's House Bill 2993. And what that bill is taking aim at is closing the racial equity gap in healthcare and making agencies that do rules talk about how this rule would specifically help close the racial equity gap, in that, you know, certain races and colors, you have different health outcomes based on simply on your race. And so we have to ask our RACs or our advisory groups or councils a series of questions, and this will be included in the rulemaking. Does that make sense to everybody?
Yes.
Yep.
Fantastic. I love this group. You guys are so with it. So we have a series of questions that we have to ask, and this is an open discussion. I've done some research to get us started. Essentially, we need to find out who is subject to the rule that we're going to file. And my answer to that was it impacts advisory council and hearing aid authorization holders, anyone who's licensed. Are we comfortable with that, or do we want to then extend to clients? You know, any thoughts?
Well, this is Sylvie. I think it would affect clients.
Mm-hmm.
Because obviously, if I have a minor who I thought I could take in and have a medical waiver signed for and get a hearing aid for, and now I can't, it would obviously affect them.
For the practitioners, do you get a lot of minors coming through? Can you give me a sense of how many you might see in a year, or do you have any statistics or places where I could look? I mean, again, the turnaround on this is very quick, but do you have any thoughts on how many minors come in and might receive these waivers, and what does that look like?
This is Tiffany, and in 15 years, I've only seen a couple of people who were minors, and in both cases, I was not comfortable seeing the person. I really wanted the child to see an audiologist, speech pathologist, and so not really common. I don't think that we deal with minors as a hearing aid dispenser, but that's my opinion.
No, that's useful. Other practitioners, can you contribute?
This is Doug. I've had probably about 5 over the last 17, 18 years. But, you know, the referrals from doctors, they just didn't want to spend the money at an audiologist than where we were at. So we were able to, you know, give them that price. But that's about it. Not very many at all.
This is Verheiden. I'm actually a physician. Honestly, usually people have to have a parent or guardian with them, legal parent or guardian if they're under 18, or they have to have some kind of documentation. But I can't comment on because they would not, according to this current situation, they would not even come to see me. So, but I do think there is an impact.
Okay. And Lorraine, do you have any feedback?
Sure. In the 13 years that I've been practicing as a dispenser, I have not seen any children in my practice, in my office. If I did, I would likely refer them to a physician, to an ENT or audiologist. I just think that's the appropriate place for minors to get help for their hearing.
Okay. Fantastic. So to some of the questions that 2993 requires us to ask, are there any specific racial groups that would be affected by the rule disproportionately?
Tiffany, not that I can see.
Yeah.
Again, my opinion.
This is Verheiden. This seems to be relating to age, but so I don't really foresee any issues with regards to race or ethnicity.
Okay.
Henry, I'm sorry.
No, please go ahead.
I don't see, or I'm not aware of any particular race or ethnic groups that would be disproportionately impacted by the rule.
Okay. Okay. Are there any racial groups that are more likely to be concerned by the issues in this rule?
Not that I'm aware of. Henricus, not that I'm aware of.
Okay. Okay. I actually did some research that I'll be adding to your rulemaking that I found according to the National Institute on Deafness and Other Communication Disorders about the numbers of children that are born with hearing disorders and the racial ethnicity breakdown for some of those. So I'll be including that. And I appreciate your feedback in those areas. I do know that some of the authorization holders within your council are do identify as Asian, Alaska Native, so I can also include that information in my filing. Heather, have I touched on all the bases? I think we kind of got there.
taking myself off mute. Sorry for the delay.
Not at all.
So that racial equity statement is part of the new filing requirements starting this year. And I think that you have gathered some information from the board that will help you get that filed. The intentional considerations we want to make sure that we're looking at here is trying to find out where there are potential different impacts, and so that those can be highlighted in the racial equity statement. So I think that you asked some questions to get at that information. If any of the council members think that there's anything else, any other comments as to how the rule might affect the fair, just, and unbiased treatment of people of different races, then that's the type of information that would be helpful for HLO as they're drafting this document.
No.
Okay. And did you need anything else from them?
I just wanted to let you know that if everything goes according to plan, we don't have any, power outages or SOS go down or whatever. I'm hoping to get these rules filed. They will appear in the March 1, 2022 Oregon Bulletin, which is the first step. We file a proposed rule and it goes out. Licensees and interested parties will all receive the notification. I will begin to gather public comment. The comment should be, we don't have a lot of wiggle room on this. I mean, it's not controversial per se, it's something that just has to be removed. So I'll do the minimum public comment period time, which is 28 days. And I'm hoping to file the permanent rule on March 30th, thereabout. And hopefully this will go into effect on April 15th of this year. We are hoping that Sylvie's been working diligently to try to get this statutory repair in the 2023 housekeeping bill for Oregon Health Authority. We're one of their many satellites, and they collect lists of things that need to be fixed legislatively, and they just do these great big laundry lists, and Sylvie's already taken steps in that direction. So I believe that's everything we need. Sylvie, are you satisfied? Do we have everything?
I am. Does anybody have any questions for us about this process? And I know it's going to happen real fast, but there's a timeline. So, and it's not a huge, it's just eliminating the the stuff that contradicts the federal guidelines. So
yeah, the problematic language.
I think we're good.
Okay. Well, then, if there's nothing else, Doug, you have a closing statement.
Oh, hang on. Sylvie, could you stay on after the meeting? I just have another question for you.
Yes.
Thank you. Sorry, Doug, go ahead.
Okay. The Advisory Council on Hearing Aids meeting is adjourned at 3/18/2022, February 15th.